I think the members, I think we all believe very strongly that the next step is to begin proceedings to hold the Attorney General in contempt for the failure to comply with the subpoena yesterday. I think we are all pressing our chairman to do that. He's, as he has been, attempting to negotiate in good faith to see if the Attorney General will do it voluntarily. But in the absence of an agreement there, it is our position that the Attorney General is in contempt of Congress, that we have a responsibility to compel his compliance with a lawfully issued subpoena, because as I said earlier, if the executive branch can willfully violate lawfully issued subpoenas, they will have successfully eliminated congressional oversight. It cannot be up to the executive branch to decide what witnesses and what evidence we will collect in our constitutionally mandated oversight responsibility. So the next step will be an effort to begin proceedings to hold the Attorney General in contempt if, in fact, this negotiation or conversation doesn't result in an agreement.
Democrats are not rushing toward impeachment, but neither are we afraid of it. The format that we're using is a format to be able to educate the Congress and the American people about how much untruth has been said. These are dangerous times because if we set the precedent as General Barr has done, who is next not to respond to the Congress? What cabinet officer in the midst of a crisis? Is it the acting Department of Homeland Security Secretary in the midst of a crisis? Is it the Health and Human Services? So one of the things that we will continue to do is use possibly the contempt proceeding, as our chairman may decide to do. In addition, we will not take off an ultimate act that we are allowed to do under the Constitution. But let me show you the example. When the tapes were found with Richard Nixon, the American people said enough is enough. I can assure you, as we build the blocks of finding out the truth, there is still that proceeding, but we will not be baited into it as our friends in the committee choose to try and do. We will only do it as this Constitution gives us the power to do. So we're not intimidated by the fact that it may be a little longer. The idea of the attorneys, as many have seen, is the continuity of questioning. That means that you can cross-examine in the midst of your time frame. Collectively, the excellent members of Congress that are on this committee, I have been stunned and excited by their questioning and their thoughts. We will put all that together. But what happens when the lawyers, and I have been on impeachment proceedings in this committee, judges and others, is the line of reasoning that allows even the American people to see the building blocks and the story narrative of truth that is so very important.
But understand the stakes. What we are witnessing is the slow loss of our democratic republic. And we can either allow it to happen or we can stand up against it. Some of my colleagues on the other side of the aisle, they're behaving like a cover-up caucus for this president, a wholly owned subsidiary of the Trump administration. That is not what the founding fathers envisioned. And so we are not going to allow the notion of a presidential dictatorship to take hold. This is a democracy. We're a separate and co-equal branch of government. And we are going to uphold that principle by any means necessary.
My colleagues keep saying we are a co-equal branch of government. We are at least a co-equal branch of government. We are Article 1. Before Article 2, we are the lawmaking power of the American people. We are the direct representatives of the American people, and the president's job is just to take care that the laws are faithfully executed, not to make sure that the laws are thwarted and frustrated and violated. And yet the entire administration is now in a full-blown cover-up mode to try to hide the contents of Special Counsel Mueller's report. And all that Attorney General Barr did was to try to tell a false story to the American people about what was in there, and they continue to scramble to throw out more and more propaganda to cover up what's really in there. We are going to get to the bottom of this. We are going to have the real facts come out to the American people. We are going to allow the American people to hear directly from the witnesses including Special Counsel Mueller, including Don McGahn, the White House counsel, about what the president did to obstruct justice. Because if we allow a president to obstruct justice and to convert the government of the United States into a money-making vehicle for himself and his family and his business, then that will set a precedent that generations to come will regret and lament. We've got a constitutional responsibility here, and we're going to fulfill it.
The failure of Attorney General Barr to come to the hearing today is simply another step in the administration's growing attack on American democracy and its attack on the right of Congress to be a coordinate branch of government and to have the information it needs to legislate and act on behalf of the American people. The administration, by its policy of across-the-board defiance of congressional subpoenas, and is saying that only the executive matters, that we don't want limitations by Congress that the Constitution imposes on us. This is a grave danger for American democracy, and we must do all we can in the name of the American people to ensure that when the Trump administration ends, we have as robust a democracy to hand to our children as was handed to us. And today is a day of testing, and everyone will be judged by history in terms of how they react to this.
Mr. Chairman, how concerned are you that this is all just going to get bogged down in the courts, and that because of your insistence on letting staff attorneys do some questioning, that it will now take even longer for you to get the answers that you've been demanding?
We are going to use what process we have in the courts and elsewhere to get the answers and the information we need. In particular, the subpoena for the entire unredacted Mueller report and the underlying documents was due yesterday. The Attorney General, we got a letter late last night refusing to adhere to the subpoena. This is indefensible, and it is part of the attack on American democracy by this administration. We will make one more good faith attempt to negotiate and to get the access to the report that we need, and then if we don't get that, we will proceed to hold the Attorney General in contempt, and we'll go from there.
Mr. General, why not negotiate a bit of?
How long are you going to give the Attorney General to answer your questions and to negotiate a good faith before you hold it?
A day or two.
Mr. Chairman, why not?
By the end of the week, you want this resolved?
Maybe by Monday, we'll see.
Mr. Chairman, why not negotiate a middle ground about the format of today's hearing? I mean, haven't you, in a sense, made it harder to get the answers that you've been asking for?
We cannot concede to the administration the ability to control the manner in which Congress does its job. The Attorney General is bound, as are other witnesses, to come before the committee, and he cannot dictate to us how we will do our job. We feel this is the most effective way of doing it, and that's our decision.
Will you insist on staff attorneys for the Mueller interview?
Using fines as part of the inherent. Your colleague, before you came out, brought up the idea of maybe imposing fines under inherent contempt as a way to try to get him to comply. Is that something that's on the table? How would that work? That's not something you see every day.
We will explore all the options, and inherent contempt is certainly one of the options.
How do you respond to the DOJ saying that you're a lawyer? Why can't you question Attorney General Barr yourself?
The administration, the Attorney General apparently is afraid of proper cross-examination. We ask questions under the 5-minute rule, and we've seen a pattern from this administration. The administration witnesses filibuster for 4.5 minutes, and then give a non-responsive answer for the next half a minute, and then it's on to a different questioner who may have other questions in mind or may not properly follow up the way a good cross-examiner would. So we feel the best way of doing this is to have all our members ask their 5-minute questions each, and have counsel be able to bat cleanup, so to speak, at the end, follow loose ends, and be able to hold the witness, the Attorney General in this case, to ask follow-up questions so that he can't evade as easily as he can. And obviously, the Attorney General is afraid to face that kind of questioning. I mean, what we saw today is, besides the attitude of contempt the administration has for Congress, what we saw was fear. Fear of effective cross-examination, period.